Hi everyone, this is U.S. Immigration Attorney Sharifa Tharpe coming on live to talk to you. I always like to close out the night with you by taking your immigration related questions. So go ahead, join me and drop your questions in the comments. I would love to hear your questions. So I usually come with a topic as well. And the topic I'm going to be talking about is called the Unlawful Presence Waiver. So all about that unlawful presence waiver. It's one of the ways to fix your immigration status if you're in the United States and you're living in the United States without your papers. But I just want you to keep in mind that even though I will be talking about that topic today, you are my priority. Your questions are my priority. So don't worry about interrupting me. Type your questions as I speak, and then as soon as I see your questions coming in, I will answer. So I just want to give you a little introduction for those of you who don't know me. I'm U.S. Immigration Attorney Sharifa Tharpe. I work at ST Law Office, and you can check out the website to learn all about me. The website is through the link in my bio, and there you will get my contact information. So I'm going to go ahead and put my number in the comments. So it's 561-405-4889. So I'm under the immigration attorney. You can write down that number, or if you miss it, you can always go to the website and get the contact information there. Sometimes the phone lines are busy, and our receptionist may not get to you right away because of that. Doesn't happen often, but it does happen. And if it does happen, always feel free to just complete the information in the contact form, and we will get back to you during the next business day. So that unlawful presence waiver, who qualifies for it? So when I say waiver, I mean applying for forgiveness for living in the United States without your papers. And so this applies mainly to individuals who have lived or are living in the United States without their status, and they've been doing that for more than 3 months, so more than 90 days in the country. So, or is it, I believe, or 180 days, I apologize. So it's more than 180 days. If that is the case, then you will, if you leave the country, if you're living here without your legal status, and for that period of time, and then you leave the country, you will be barred for you'll be barred for 3 years. If you've been living in the country for more than a year, then you'll be barred for 10 years. So it's usually the case where if you are here and you're living without your status, you can't leave, or you won't be able to return. And so in cases like that, the unlawful presence waiver may be your only way to fix your status. So I filed a I-130 bundle with my kids and did not receive a biometrics for one of them. What to do? So I would want to know what the circumstances are. Sometimes it may be that the one of them is taking longer. So if you are doing a bundle for your kids, so if you're a U.S. citizen and you're applying for the adjustment of status, which that's why you have the biometrics appointment, it's still treated as individual I-130 applications, and so that one may still be in process. But what I would suggest you do is give them a call. And make sure everything is okay with that particular application. You can go to the uscis.gov website, and then also the numbers at the bottom of the receipt notice. So you can call that number and let them know what's going on and just make sure everything is good on your end. So keep those questions coming. So I was saying, if you're living in the United States for a period of time, then you cannot leave the country. If you leave the country, then you'll be barred from returning to the US. So in a case like that, the only way maybe to fix your status through applying for what's called the Unlawful Presence Waiver. And that's basically asking for forgiveness for living in the United States without your papers. So who qualifies for this and how does it work? So in order to apply for this type of waiver, you will need to have a U.S. citizen or a legal permanent resident, spouse or parent who will experience extreme hardships if you are not granted the waiver. So what does extreme hardship mean? So it is not your extreme hardship. It's going to be the extreme hardship of your U.S. citizen or legal permanent resident, spouse or parent or both. So extreme hardship doesn't mean that they're going to miss you if you leave or they're going to be merely inconvenienced. Extreme hardship usually means that they'll experience exceedingly difficult circumstances, such as financial issues. They'll be at risk of losing their home. They need you present because they need you, for example, if it's a parent or even a spouse who has health issues, they need you there to be the caretaker. They need you there to take care of the kids if you share kids with your spouse. So that's not a comprehensive list or example of the extreme hardships, but those are examples of the kind of extreme hardships that your U.S. citizen or legal permanent resident, spouse or parent should be experiencing. Jason Tyson 59, what makes you qualify for a U.S. visa? So with the U.S. visa, so if you're talking about the visitor's visa, then with the U.S. visa, you will need to show that you have strong ties to your home country that will convince the officer that you will return to your home country after you visit temporarily. So usually when you go into that interview, you need to make sure you can show that you have commitments in your country. You have a home, you have property, you have a job, you have future commitments, you have debt, you have children, you have a spouse, all of which live in the country. So that is the main concern of the officer and this is for a visitor's visa. Now, obviously, if you're talking about another type of visa, the criteria and qualifications change, but I'm talking about the visitor's visa. So user 9038, I did call them and they could not tell me why. My husband petitioned for us, he's a U.S. citizen. So if you call and they couldn't tell you why, they don't need any further information. It may just be that they are a little backlogged and that one application got delayed. As long as they can tell you that it's still in process and nothing is going on. Now, I can't tell you specifically. What I'm saying is just guessing on my part. If you would like to, get a consultation to determine if there are any problematic issues in your case or if there's something you're thinking about, you can always give the office a call. But my assumption here is that if nothing is going on their end, it's just that one child's application may have been, slower than the rest, unfortunately. So Island Thick Chick, how long does citizenship take? So I've seen it as short as 6 months right now, even during the delays. So if you're thinking about applying, now is a good time to do it. So user 9038, the biometrics is next week. Should I take her? She will be 18 in August. So I don't want to advise you as to what to do because I don't know what the situation is. I don't know what the circumstances are, the facts are. I don't know what your daughter's circle. So I can't tell you specifically whether to take her in or not. Usually, in order to get the biometrics for an individual, generally speaking, you must have the appointment set. And so it's not usually, they don't allow walk-ins for a biometrics appointment. Sweetness 777. If I would like to work in the US, what type of visa do I need? So it all depends on your qualifications, the employer. So that would definitely require consultation to determine exactly what you qualify for, because there is such a broad there's so many employment-based visas, and each employment-based visa or green card depends on what the qualifications are, what the needs of the employer are, what the needs of the country are. And so if you really would like to explore your options to get an employment-based visa, then you can always call and schedule a consultation. So Jason Tyson, can I apply for a US visa? So yes, you can apply for a US visa. There are no limitations on you applying for the visa. You of course would bear the risk of denial. Of course, that's always a possibility, but just make sure that you're prepared. Now, with the debts, you would want to show, so for example, your mortgage is a debt, and the mortgage is also a good evidence of your ties, your ownership of property, and your strong ties to the country. So you're welcome, user 9038. So keep those questions coming. I am talking about the unlawful presence waiver. So Gray Demarg Granado is, what do you know about the Venezuelan TPS? So right now they have announced that Venezuelans are eligible for TPS if you're currently in the country. So you have to meet specific criteria, of course. And if you want to see if you qualify, you can always schedule a consultation with me. But that TPS allows you to stay in the United States for a designated period of time. And usually TPS will last as long as the instability in the country lasts. So Jason Tyson 59, if I want to work in the US as a truck driver, how do I apply? So you would need to find a company that is hiring foreign workers to work as a truck driver. Unfortunately, I don't seek the employer, but I do advise clients once they find the employer and they want to move forward with the process. What if you have a car loan? Is that a good debt? So that is definitely something to show that you have a car in your possession, and that you have debt that you owe. It may not be strong evidence because anybody can leave behind a car loan, but it would definitely, that along with other evidence would definitely could show your ownership of property and your strong ties and the fact that you've settled in the country. So you're welcome, Sweetness 777. So keep those questions coming. I'm talking about the unlawful presence waiver. So if you are here without your papers and you have a U.S. citizen or legal permanent resident, spouse or parent who will experience extreme hardships if you are not granted a green card, then you would qualify for this waiver. Extreme hardships usually means something more than a mere inconvenience. You will need to be experiencing, so usually those hardships could fall into categories like it affects employment, it affects your finances, it affects your health, it affects your childcare. If, for example, your spouse is a U.S. citizen or legal permanent resident and they'll have to relocate to the country, your home country because if you're not granted a green card, then you would be looking at the cultural issues, the language barrier, the crime in your home country to show why your relative would not be able to relocate with you. So this is a complex type of waiver application. It's not just filling out forms and writing out a little statement. It does take a lot of strategy, and so it is something that I do for my clients to help them along with the green card. So where does the waiver application fall in the entire green card process in order to fix your immigration status and then get the green card? So you're welcome, Jason. Chef Andre Davis, it's nice to see you here again. What if you don't have a relative or spouse and you want to apply for a green card? So if you don't have a relative, you don't have a spouse, then the other options would be employment-based or through Humanitarian. So Humanitarian would be filing for asylum, which would mean that you have a fear of returning to your home country because a group that you belong to, for example, if you're a part of a religious group that's being persecuted in your country, that could be a basis for asylum. If you're being persecuted because of, so you have to be a part of a protected class. So if you're being persecuted based on your race, on your gender, on your religion, on your ethnicity, or any other type of particular social group, then you could apply for asylum. So that's one other option. As I said before, employment and other humanitarian type visas. So this is not directly a green card, but it can eventually lead to a green card. Is the T and the U visa. So if you came to the United States because of trafficking, labor, or sex trafficking, or if you were the victim of a crime while being in the U.S., this could also eventually lead to a green card. First, you would be granted a visa to stay here 4 years and work, and then after that, you would be able to get a green card after 3 years of having the T or U visa. Hi there, Afro Girl. So keep those questions coming. These are all great questions. So how does that waiver fit into the whole green card process, right? So the first thing is, if you have someone who is going to apply for the green card for you, an employer or a family member, and then what will happen is the employer will file the petition, or the family member will file that initial application. Once it's approved, so that initial application usually requires you to show that you qualify for the green card through the relative or through the employer. Once that's approved, you take the approved petition and then prepare that waiver, which, as I said before, is not just about filling out forms, but it's about attaching a brief, attaching a cover letter, attaching evidence along with the relevant forms and the application fee, of course. You would submit that and with the approved waiver, and if it's approved, then the green card process would continue. It would be sent to your home country, the U.S. Embassy in your home country. And then once they set the appointment, you can buy your ticket, fly out with your approved waiver, and attend the green card interview, and your unlawful presence will not be held against you. So let's see, we have some more questions. So Devil's Angel 2. Hi, I applied almost a year and no reply. What should I do? So definitely, I don't know what you applied for, but you should definitely check on the status of your application, because that is definitely something that's strange if you haven't received anything in a year. So the first thing I would do is contact USCIS and inquire into whether they even have the application. So AfroGirl02, So they asked me for more evidence. You send it a week ago when they will let me know. So usually they do take about 4 weeks or more, and I believe they have a maximum of 120 days to respond to that request for evidence. Hi there, PB10 USA. It's nice to see you. So my husband applied for my green card and I didn't even get back the receipt yet. So yes, you want to make sure that it has not been lost in the mail, that they did get it. So give them a call and see if they can track it down for you, because maybe the receipt notice got lost in the mail or something, or maybe they didn't get it. So you want to definitely give them a call, because a year is very long. So keep those questions coming. So PB10 USA, can asylum seeker get green card after marriage without going back to the home country? So yes, so the green card, the asylum seeker, yes, if they do get the green card, they can get the green card through marriage. So yes, that is a possibility. But you want to make sure that you qualify and that everything is good moving forward. There are no disqualifying factors in your particular circumstance. So I was talking about that unlawful presence waiver, which is one way to fix the your immigration status in the United States. Okay, so Devil's Angel, the paralegal that applied for us made us call. I called service center, they don't have it, and I emailed lockbox and no reply. So, you know, if they don't have it, and if they say they have no record of you, then it may just be that it didn't get there. So you want to make sure you check into that. And, you know, get legal advice as well. Make sure you're doing it right, because I see here that a paralegal applied for you, and the paralegal is not the same as an attorney. And so you want to make sure that, first of all, that it got there, that something was, that this person did apply. And furthermore, you want to make sure that you qualify for whatever has been submitted. And usually when you file electronically, you do get correspondence right away. So that is a bit strange. So I would be cautious and make sure that you get legal advice before moving forward with your application. If you would like to schedule a consultation, you can give me a call at 561-405-4889. So keep your questions coming. I want to hear your immigration questions, and your questions are my priority. So I was talking about that waiver that's basically applying for forgiveness for living in the United States. Once you have the approved waiver, you can go to your home country and complete the green card process there, and then you would get the immigrant visa and then come back. Eddie Pitt called your office about an asylum, but the cost to speak to you, do we pay another to you? So there is one consultation fee, and I believe that the scheduling coordinator probably spoke to you about the cost, and that is one fee, and that is you would pay that one fee, and then that confirms your appointment. So PB10 USA, my lawyer filed the I-130 for me. We got interviewing 4 months ago. It's showing case must be reviewed. So I'm seeing a lot of those lately, and where the interview came very quickly and then the case is sitting in review for a long time. Unfortunately, I'm seeing that more and more. So speak to your lawyer and see what your lawyer can do. So keep your questions coming. I want to hear your immigration questions. So I just covered how to fix your immigration status through so PB10 USA. So now she's not helping us. So you want to make sure that this attorney is qualified to do what she's doing, qualified to apply for you, because as the attorney, it depends on what your agreement was with them. But if they are representing you throughout the process, then this attorney would be obligated to keep in touch with you and let you know. So you definitely would want to first be insistent and contact your attorney to find out what's going on. And if not, definitely seek a second opinion and get help. So Jerry Figueroa, tell us a little about VAWA case. Who can apply? So great. Yes, definitely. So in order to apply for VAWA, you have to have a U.S. citizen or a legal permanent resident parent. So if it's a parent, you have to be under 25, or a spouse, or even a citizen son or daughter who's 21 and up, and they're mistreating you. So that's the first thing. You have to have these relatives. Usually you have the abuse or mistreatment has to be occurring in the United States. Now, they have the U.S. citizen or legal permanent resident, spouse, parent, or citizen son or daughter who's 21 and up, they have to be mistreating you. And mistreatment does not mean that you have to, they have to be hitting you, or the police have to be involved, or you have to have physical injuries. Of course, that qualifies as well, but it can be emotional. It can be extreme cruelty, not just physical abuse, extreme cruelty. And what this does, so that is, I am glad you brought this up, because this is also one way to fix your status in the United States, especially when you're not getting help from these relatives. And you are right, emotional abuse definitely counts. So emotional abuse, name calling, financial control even counts. If they even threaten you and say they're not going to apply for the green card because you're not doing what they say, or they hold it over your head, that qualifies. So definitely keep that in mind. There is a misconception that it requires hitting or physical violence, and it does not. So in order to apply, you would first submit the necessary forms, and then after a couple months, and it depends on who your relative is. So if it's a U.S. citizen, spouse or parent, or a U.S. citizen, son or daughter, 21 and up, you would file your adjustment of status application along with the other forms, and then with the work permit, and then about 6 to 8 months, you'll get your work permit. And then after that, you will get a decision in the mail to say whether it is approved. If it's approved, you move on to the final interview to get your green card through the adjustment of status application. So so with U.S. citizen spouse, you would definitely apply, submit the work permit, the travel document if you want a travel document, along with the necessary forms, and then that would allow you to get a work permit while you wait. Now, I want to let you know that this is also a complex, you don't want to make any mistakes on it. If you're being emotionally abused, this is something that I focus on in my practice, and I can help you. So give me a call and schedule a consultation with me, and then we can talk more about your particular circumstances and get started on an application. But it is a good way to fix your immigration status if you are currently going through this. So Camp 356 is the public charge rule still in effect. The new public charge rule is not in effect anymore. That was the one that looked at your background as the immigrant, so looked at your education, your age, your medical history, your family status, your financial history. So that is not in effect, but they still require the affidavit of support, and they require somebody to sponsor you. I had applied from October, and they said more information in regards to the public charge. So that was before they withdrew the RFE. You're welcome, Jerry. So it's no longer in effect. But if I would not be able to advise you on what you need to respond to, because of course I would want to review your case before I tell you how to respond to any kind of information they're requesting. So Hope Brooks 36, parents with green cards and kids are over the age of 21. So Hope Brooks, let me see. I think your question is I noticed that your question, it doesn't seem complete. But if you do have parents with the green card and the kids are over 21, and if you're in the United States, you would likely have an out of status. So if you have status and you can maintain that visa or that status for the duration of the time that you're in the US, then your green card, and this process is usually taking about 5 to 6 years for children, so adult children over the age of 21. If that's the case, you do not have your status, then you will need to apply for that unlawful presence waiver that I talked about earlier. But give me a call and schedule a consultation, and let's talk more about what your situation is. So I am pretty much complete with the topic that I came with, and I always enjoy closing out the night with you. Thank you all. Hope Brooks, you're welcome. Thank you all for your questions. I'm here every day. So if I missed your question, or if I did not, hi there, Miguel, it's nice to see you. If I missed your question, or Miguel, yes, I'm about to close out. But I am here every single day. So teacher Steve 37, can an immigration judge approve an I-485 application if a master hearing for removal was put off? So usually that approval for the I-485 application has to be at the final hearing. So the judge can approve an adjustment of status. Usually, if you have a pending I-485 application at the USCIS, then the judge, what they'll do is sometimes the attorney will request that there be a continuance while the process is pending at the USCIS. But in some circumstances, a judge can approve the green card through adjustment of status at a final hearing, usually not at a master hearing. So thank you all for your questions. I'm here every day, so tune in, follow me if you're not following me to get notice when I come on, and that way you can ask your questions again. Have a good night, everyone. Bye.